person for a few weeks or for a few months for whatever reason is the only, and eventually you are able to conduct an evaluation, are you able to rely on other sources of information to triangulate or to verify impressions and conclusions that you might reach, other than simply the psychiatric interview?
Correct. Well, we have history. We have the documents. If the person is in hospital, you have the hospital records. If the person is incarcerated, you have the records of the incarceration. If it's in a jail, you have the observations of the jail nurse. You have the observations of family that are visited, the observations of a lawyer who's working or has worked with the client. So there are other things.
Anyone who the lawyer might have introduced, to see the client?
If the lawyer hires someone else to see his client prior to us, certainly they don't have to make that available, but they generally do, and we take that into account. We might not agree with it, but we take it into account.
And you can derive information from
yes,
those sorts of sources. If I told you hypothetically that a defendant was alone with the sheriff and chief investigating officer for a period of time when the case was first solved, when the confession was first made, and that chief investigating officer was able to carefully observe her, talk to her, is that a source of information which would be helpful to you?
That's a source of information. A taped interview, of course, is much, much better. If you can actually videotape or audio tape that interaction, that's much better in terms of the issue of, generally that issue is competency to confess.
And if law enforcement failed to make such a recording at the time when it could have been made, then no amount of psychiatric evaluation closer or later or at any other time following a person's arrest is going to bring such a record into existence, isn't it?
No.
That opportunity is gone, isn't it?
Yes, sir.
I have no further questions.
I do have one other question. This particular incident, by virtue of what has occurred, and there are videos and audios of the defendant at various stages prior to her arrest. Would review of those be of any assistance in making the determination as to not competent to stand trial, but as to the McNaughton criminal responsibility standard? Would they be of some help or not? Again, from the time, as I understand the facts, an incident was reported, investigations were made, then an arrest was made, and during that time frame, interviews were taped, recorded, videoed, perhaps oral statements were made that were not captured such as that, but by note-taking. What, if any, assistance would those be in making this evaluation, if any?
They would be extremely helpful. Extremely helpful.
And they are memorialized and they will be as available later as they are today?
Yes, sir.
Mr. Lister? Mr. Brooks? Sir. Thank you, Dr. Moore. Good to see you again. Appreciate it.
Please, Gordon, Your Honor, based on Dr. Morgan's testimony, and I think that's the issue, not could you do it later, but what is ideal? Because one of the purposes we have here is obviously to seek the truth, and if there's a determination of insanity or whatever determination may be made, it is incumbent or proper for the court, for the defense, for the state, for everyone to know what the true issue is or the true factors in this matter. He said, unless I'm misunderstood, that although there are numerous ways to do it 5 years later, that the ideal situation is to see it right now. To see her right now, to do the evaluations, and I point out again that he's objective, and by the state pushing it, we're not pushing it to get any advantage. Because he may very well rule that she is insane, Your Honor.
I certainly don't believe that's the state's purpose, that is, to gain any advantage. I certainly think the state is sincere in making this request, and that question never crossed my mind. So I respect the sincerity of the state.
Your Honor, I would allude, and then I'll move on to other issues that Mr. Bruck pointed out, a prime example of why something needs to be done now. He alluded to the officers and a video, and that opportunity was lost because a video was not made of when she was being spoken to right at that time. Well, by the same token, the opportunity is here for Dr. Morgan as soon as possible in Ms. Smith's current state to deal with her now. If we don't deal with that right now, then that opportunity will be lost. And so as we continue to delay, more and more opportunities to seek the truth, more and more opportunities to get a true picture will be lost as this is pushed down and as this is delayed. Your Honor, the other part in the motion, I want to clarify that, and again, it kind of goes with our 5F motion of the notice on insanity or guilty but mentally ill, was the section where I discussed the state reserving the right to have their own expert. The purpose of that motion, Your Honor, is that the defense does notice us of an insanity defense or guilty but mentally ill after the state doctors in Columbia have given an objective evaluation. If there becomes some obscure mental deficiency that they're reporting that she has, then obviously the state would want to reserve the right to find an expert just as they will do, or just as they have done, to find an expert that can also speak to those matters. That was, in essence, the crux of Section 3 in that order, was just to reserve that right. And again, it may be premature from the standpoint that we haven't seen the 10 days run, but the state would reserve that right to have an expert called in. Again, Mr. Bruck obviously has some concern. He's given some indication that he is having someone see her. Obviously, he's thinking there's a mental issue. We need to get it before these objective examiners and make a determination of whether or not there's an issue.
Thank you, Mr. Bruck.
Thank you, Your Honor. I'd like to take the state's motion one request at a time. First, the state has moved for an order requiring a determination of Susan Smith's competency to stand trial. Excuse me. Two things to be said about that. First is the state apparently submits that the portions of her confession are reason to believe that she may be presently incompetent by reason of mental illness. Now that is a question, of course, that the court will have to resolve. I would point out statute does not authorize an evaluation whenever there is the slightest suggestion that mental condition may be an issue or a question in a criminal case. It authorizes the court to require a compulsory evaluation, a non-privileged, non-confidential evaluation, only when the court has reason to believe that the person on trial before him is incompetent to stand trial. Now, since this request is framed as it must be in terms of the statute of South Carolina, I have to interpret the solicitor's argument concerning that statement as an argument that that statement by itself should cause the court to believe that, as we sit here, Susan is incompetent to stand trial. That is the court's position, is one that the court, if that is the state's position, of course, that is a question of fact for the court to resolve. And I simply want to make clear what the legal question standard before Your Honor is. Secondly, of course, we're way ahead of ourselves. The question of competency to stand trial is something that arises at the time of trial or close to it. If Your Honor were to order an evaluation of Susan's competency to stand trial today, you obviously have to order another evaluation of her competency to stand trial when she's fixing to be tried. So the motion is, to put it mildly, premature. That brings me to the question of the state's second request, which is for Dr. Morgan and his staff at the Hall Institute to perform an evaluation of Susan Smith's criminal responsibility as of October 25th, 1994. Now, at the very time that the state, of course, this only becomes an issue, as Your Honor well knows, if Susan pleads insanity or guilty but mentally ill. And there is a procedure under our law to determine whether or not a defendant intends to enter that plea. And the state did not avail themselves of that procedure until 2 days ago, when I was served with a fax asking me to state within 10 days whether Susan is going to plead not guilty by reason of insanity or guilty but mentally ill. Of course, there's 8 days still to go. And I don't mind telling you that neither today nor 8 days from now will I be in a position to answer that question. The information that I have about this crime from the state, that is to say the results of the state's investigation, consists of a 2-page statement that's just been handed to you, 2 arrest warrants, and 2 boilerplate Miranda waiver forms. Now, the solicitor has assured me that as soon as he receives the case file from SLED, which I anticipate will be voluminous, he will immediately copy that file and provide it to me. And I want to make clear that I don't have the slightest reason to doubt that the solicitor is acting in complete good faith and that he will follow through on that promise. But obviously, no one can decide what plea a client should enter until the lawyer knows what the facts of the case are. And I will not know what the facts of this case really are, as opposed to what's been reported in the media, until I get the state's evidence. So neither today nor probably when a truckload of papers and evidence is deposited in my office some week or 2 weeks or 3 weeks from now will I instantaneously be able to respond to that notice. Until the notice is responded to, there is simply no issue in the case that requires a determination of criminal responsibility. Now, the solicitor, I think, betrayed the weakness in the state's case when he said that it would be ideal from the state's point of view if they could have an evaluation of Susan that would not be privileged, that would not be confidential, and that they could use against her as they saw fit. It would be ideal in a burglary case. It would be ideal in a case involving alibi. It would be ideal in a case involving self-defense for the state to be able to obtain what amounts to a search warrant for the inside of the defendant's mind, and to get that defendant away to be questioned at the state's until the state was satisfied that they had everything that would help their case out of that defendant. That might, from a law enforcement perspective, be ideal, but it is not the way we work in this democratic society. And one of the protections that a defendant has once she has been arrested, and once formal proceedings like those that we did today have begun, and once she has gotten herself a lawyer, or one has been appointed for her, is that the state just doesn't have the right anymore to have that kind of foraging around to see what's going to help their case out of the defendant's mouth. So we are not, if you want to put it that way, living in an ideal world, and thank God for it. That is the difference between our country and the conditions in countries where people get into rickety boats to come here. That is one of the differences, and I make no apology for that whatsoever. Now, I have to say that I feel very uneasy opposing the state's motion, because it is my job to find out what happened, and to find out why this terrible tragedy occurred. And I am getting all the help I can muster, and I would appreciate the help that Dr. Morgan could provide and his staff. And were it possible, I would avail myself of that assistance. There is a 3-word reason why I cannot do so as Susan's attorney, and why at this time, at this very early stage, I have to protect her from this request by the state. And those 3 words are the death penalty. I'd like to explain if I may. The solicitor has indicated, as is entirely proper under the laws of this state, that this case could qualify for prosecution as a capital case, and that he will eventually, in good time, after consulting and thinking the matter over, decide whether the state is going to seek the death penalty against this young woman or not. At this point, as her attorney, I must assume the worst. That's what a lawyer is for. The law in this state is as follows regarding a psychiatric evaluation in a capital case. A defendant who consents to have her sanity evaluated by the South Carolina Department of Mental Health, that is to say by Dr. Morgan and his staff, thereby runs the risk, whether or not she eventually pleads insanity or whether she does not, of having the results of that evaluation used against her, not on the question of was she insane or was she guilty, but on the question of whether she should be put to death by electrocution or whether she should be allowed to live out her life in prison. Now, the case that says that is Boomer versus Aiken, a Fourth Circuit decision handed down in 1988. And in the Boomer case, which I remember well because I eventually came to be Mr. Boomer's attorney, and I was there when his head was shaved and the conducting gel had been rubbed in and he was taken off to be electrocuted. What happened in the Boomer case was that his public defender saw no harm in consenting to the very motion that Mr. Pope makes today. Because after all, they probably weren't going to plead insanity anyway, so what harm would it do to allow the South Carolina Department of Mental Health to have a crack at it? And that was a reasonable way for that public defender to look at the matter. But 2 years later, when Mr. Woomer was being resentenced before a jury in Horry County, one of the psychiatrists from the Department of Mental Health popped up at his sentencing hearing to give what can only be described as quack testimony, predicting as a matter of absolute certainty that this man who had never been violent a day in his life before the murders of which he was convicted would certainly be violent every single chance he got for the rest of his life unless he was executed, and that he personally derived sadistic pleasure from making people suffer, and in effect, the only thing that a jury in its right mind could do would be to order this man to be electrocuted. Now, he had no warning that that's what could happen as a result of that evaluation of the South Carolina Department of Mental Health. And neither did his lawyer. And that is why he consented to it. And that is the testimony. And that is what the jury heard. And their verdict was death, and he is dead. Now, his lawyer can be forgiven for having made that mistake. But I am not going to make the same mistake. I'd like to tell you a very little bit about Susan. She is, at this moment, very fragile. She is regressed. She is not able to protect herself. I live near a busy street in Columbia, and there's traffic charging up and down it all day long and all night. I have a 6-year-old daughter who could probably cross that street and get to the other side safely if I let her do it by herself, but I would never let her cross that street without my holding her hand. Well, Susan right now is a lot like a 6-year-old child. She cannot defend herself. She needs to be protected. And she needs to be protected against the legal peril that I have just described to you. Now, Mr. Pope didn't write this law. He's not responsible for the condition of South Carolina law governing commitments. I have absolutely no reason to think that the conclusions that Dr. Morgan might reach if he were able to begin evaluating her tomorrow would hurt Susan. On the contrary, I believe that Dr. Morgan would be our witness when the evaluation was over, and that he would be someone that I would call and the state would have to cross-examine and try to show that he was wrong in his conclusions. But given the law as I have described it to you, I cannot take that chance. If the death penalty is not an issue in this case, everything I've been telling you about now will be moot. And I've solved that. That is a bridge, of course, that quite properly the solicitor will cross later, and therefore I submit that this evaluation is a bridge that we're going to have to cross later. Now, the solicitor was saying that this opportunity is being wasted, this opportunity is being lost, time is going by, and he analogized it to the failure of law enforcement to take a videotape or a tape recording to preserve what happened when Susan made the statement that she made. The opportunity that was lost by law enforcement can never be reconstructed, can never be regained. That is water under the bridge. Dr. Morgan said if he is ordered to evaluate her later, when her legal peril is clearer, and when it is possible for her to be protected in the way that she must be protected, he can still do an evaluation. He would prefer to do it now, but he can do it later. And on recross-examination and in response to Your Honor's questions, he made quite clear that the psychiatric interview with Susan is, while an important part of his evaluation, a fairly small part of all the information he will receive, and that he will receive enormous amounts of information. Your Honor asked about the videotapes of Susan prior to her arrest. Perfect example. There are huge amounts of information that any psychiatrist can rely on that are available now, will be available next week, and will be available 6 months from now. So, by and large, the example I use is an example of a chance that's really been lost. The issue that the solicitor is attempting to speak to you about and is citing now is an example of an opportunity that, from the point of view of one psychiatrist, will be marginally less desirable at a later time that will be excluded. And I don't think there's any analogy that can be made between them now. Now, I've told you that I'm not in a position to respond to the notice of insanity. Mr. Pope said he had understood from the media that I was considering an insanity defense, and I have to tell you, I certainly have learned a lesson in dealing with the media in the last 2 weeks. I didn't think I was a complete hayseed about it, but I've learned that I am. What he is referring to is the fact that I was asked whether I had ruled out an insanity defense at the one press conference that I was foolish enough to give in this case. And I said, I've been on this case 72 hours, I'm not ruling out anything. Never imagined that the headlines that would emerge from that is, Smith defense considering insanity plea. Well, that's the press reports that he's referring to. I have not ruled out anything. I haven't seen the state's case. I have a great deal more work to do with my own client. The ruling out will come later. But we are way ahead of ourselves trying to figure out whether there is a rush, a breakneck race for the state to have the best possible opportunity to rebut a defense that may never be asserted. And I simply suggest that we take things one step at a time. I have moved before the court for disclosure of 2 items. I interpret the solicitor to have complied with the first request, which is that I said I would move for disclosure of any and all evidence of whatever nature in the possession of the state and its agents which might reasonably constitute reason to believe that the defendant is not fit to stand trial because she lacks the capacity to understand the proceedings against her or to assist in her own defense as a result of lack of mental capacity. The solicitor will correct me if I'm wrong, but it's my understanding that the state's proof in that regard consists of her confession. If they have anything else, I move now that it be disclosed in open court. Secondly, I've moved for a listing of the most recent 20 criminal cases prosecuted by the 16th Circuit Solicitor's Office in which the state served a request for notice of an insanity defense or similar pleading under Rule 5F of the South Carolina Rules of Criminal Procedure prior to November 3rd, 1994, together with the date of the defendant's arrest in each case. I've been advised informally that the state does not believe this information to be relevant and it does not intend to produce the information sought. I'd like to say that the reason I made this request is that it is my information and my firm belief that it is not customary, regardless of everything that Mr. Pope has so eloquently stated here today, for the state of South Carolina to move within 12 days of arrest to require the defendant to provide notice of an insanity defense and, over the defendant's objections, to argue for a speedy determination of criminal responsibility even before the answer to the notice has been provided. Indeed, I believe that this is a completely unprecedented request. If I'm wrong, of course, I move to the information that will show I'm wrong. And the relevance of all this is, I think that it greatly underestimates or undercuts the solicitor's assertion that there is some terrible urgency for having an instant evaluation by Dr. Morgan and by his staff. If it is so urgent in this case, why wasn't it so urgent in the last 20 cases or the last 100 cases where this issue has come up? Or were those cases not important? Or is it only important in this case? Or should Susan Smith be treated differently than everybody else? Now, please don't misunderstand me. I don't mean this to sound like I am accusing the solicitor of doing anything improper. That is not what I'm saying at all. He has dealt fairly with me. He has handled this very difficult case in the most honorable fashion. I appreciate everything about his handling of the case up till now. But I do think, and if it is true, the solicitor alone has the data to prove me wrong, I do think if they've never made a motion like this before, if the things Dr. Morgan said are not scientific discoveries that were made yesterday, to the extent that they're true at all, if the state had never made a motion like this before, 12 days after arrest in any case, and come into court to argue against the defense attorney and urge an instant evaluation because of all the reasons stated by Mr. Pope, then the equities can't weigh as heavily on the state's side as they claim. Why for the first time now? Now, that is the reason for disclosure. The state, of course, will have to address with the court whether they intend to comply with the request or whether the state will simply stipulate to the assertion that I must make without proof to the contrary, which is that this is an unprecedented request in the circuit and that no defendant has ever been treated like this before. I might just review my notes. I think I've said everything I have to say about the issue of criminal responsibility, and I apologize for talking so long. I hadn't intended to. There is one more matter that the...
Before you move to that,
Yes.
let me just hear from each of you in regard to Rule 5F, and it's clear that late filing of the notice is allowed. I would meet that, and inherent in that, I read that the court could allow late filing, but could also extend the time in which the notice could be given. Is that your position?
Absolutely.
How about the state?
Obviously, I think it clearly leaves open, Rule 5F leaves open the discretion of the court to do what they deem appropriate, and I understand that. However, I'd like to address, if I could, as to the rule and the use of the rule. The standard way we use the rule in my brief tenure as solicitor has been through a reciprocal discovery, request for insanity, request for alibi scenario. How the court is aware that for reciprocal discovery, I have to have a discovery request. I have tried to be agreeable in that, and certainly I will have an open file discovery, but I can't do it in the standard form that we would have normally done it, because I don't have a discovery request from the defense yet. So as far, and I can address the issue, as far as the Rule 5F, bare bones, as it came out on one sheet with one motion, this is the first time that I've ever done that. Honestly, I can say that this is the first time since I've been in office that I have seen such insanity, guilty but mentally ill potential in a case. None of the cases I've dealt with yet in my brief time of being here have been insanity related. Ultimately, we've had no insanity defenses. We've had no guilty but mentally ill. So in that regard, this is the first time, and for those reasons that I put that forward this first time. However, I would note, Your Honor, that what I'm doing is availing myself to the few rules that the state is allowed to use. And one of those is that we can ask for within 10 days that we'd be given some notice. Your Honor, I can appreciate the constitutional concerns. I can appreciate the concern for the death penalty. It's my understanding that in the orders that I've dealt with, that it states in the end that no statements by the defendant and no results of the defendant's evaluation shall be used by the prosecution at trial or sentencing for any purpose other than the determination of the defendant's competency to stand trial or connection with the defense of insanity or plea of guilty but mentally ill. except that the prosecution shall be not precluded from rebuttal. So basically, Your Honor, the very protections he's concerned about as far as the death penalty, which may or may not come into play, are protected and would be protected by the structure of your order in this particular case, Your Honor. So I don't think that's an issue. What I think it boils down to, Your Honor, and certainly this is an adversarial proceeding, and I appreciate how Mr. Bruck's conducted himself. The bottom line issue is Mr. Bruck doesn't want us ever to have anybody neutral to look at it. He has already retained someone to look at her, and he would like to spend as much time as possible with her, independent of the death penalty situation, to prepare and organize an insanity defense that would preclude Dr. Morgan or anyone objective from being able to make a clear determination. And that's why the urgency is there in this issue, Your Honor. That's why, as soon as we were able to, we made this motion, this 5S motion, which again stands by itself for the reasons I've stated.
Well, the court's interested. Susan hasn't been seen by a psychiatrist from either side. Mr. Pope's hunch is correct that I'm doing everything I can to defend her. And it's in the nature of what I'm doing that I can't talk about it very much. It is not true that my purpose now is to make sure that come hell or high water, she was never seen by Dr. Morgan. As I stated at the beginning, nothing would please me more than for Dr. Morgan to be able to see her today. But there has got to be protections that don't exist under the law right now for that to happen. I wish that it was not so. I think Dr. Morgan's a good doctor, and I trust his judgment. He has excellent clinical skills, and I think he would do a good job. But the law under which I am working does not allow me to roll the dice. In the fullness of time, there will be an adequate evaluation, should one be necessary in this case, that will be fair to both sides. It's in Susan's interests for the whole truth to come out in this case. We are not going to be hiding anything. It is going to take time. And we are dealing with things which are as fragile as matters of the human mind and heart can be. And I just have to ask you to trust me when I tell you that we need to be careful and we need to go slow. That's about all I can say. I have to apologize, I think, on behalf of both of us, because all Your Honor was doing was asking us about Rule 5, and we've now received a whole bunch more arguments from both of us about other matters. Clearly, Your Honor could extend the time for responding to a reasonable period, such as 90 days, that would allow me to assess the state's case, do some work on my own, and decide whether there's an insanity defense or a guilty and mentally ill defense that ought to be asserted in this case, or whether there isn't. You heard from Dr. Morgan, I can do an evaluation then. If there's a way that I can find getting with Mr. Pope to see my way clear to agree to doing something earlier than that, I'm certainly going to do it, because as I said at the very beginning, nothing would please me more than be able to get Dr. Morgan working on this very, very sad, terrible case. I do want to try to be brief with the rest of this, and have been, but I'd like to turn to the last request the state has made. The solicitor has very forcefully argued that he only wants an evaluation by a neutral and impartial, unbiased examiner employed by the state of South Carolina, namely Dr. Morgan and the people working for him. But his motion request number 3, is a request for an expert, a psychiatrist, I suppose, of the solicitor's own choosing, who will be an advocate for the prosecution, and who also ought to have a crack at Susan. Now, this very request was made much, much later in the process. In fact, on the eve or maybe even during the trial by the state in the case of State against Jamie Wilson. And then Circuit Judge, now Associate Justice of the State Supreme Court, denied the state's request, saying there was absolutely no statutory basis for a private prosecution examiner to examine and defend on issues relating to criminal responsibility. I think Judge Moore was correct then, and I venture that Justice Moore and his colleagues would come to the same conclusion if the issue were presented to them on appeal. The statute is clear that the defendant has a right to an independent examiner during a competency evaluation, but makes no provision for a, I don't want to use the term, but in the vernacular, for a hired gun prosecutor psychiatrist to come in who does not work for the Department of Mental Health. So clearly, I suppose it's always good lawyering to, if you're asking for something you don't think you're going to get, ask for something else that you really know you're not going to get and make the first request seem a little more moderate. In any event, I think that part of the request should be denied is correct.
Do you know of any statutory or case law that, and I haven't read Wilson, he didn't allow it because there was no statute interfering with the appeal.
I should clarify that that issue is not dealt with in the opinion because it didn't come up on appeal.
All right, so there's nothing that says that, there's nothing that says that the solicitor, with or without court approval, I guess you have to have court approval before you have somebody who's out to defend that, so that's probably not a legitimate scenario. Would there be any inherent power in the court or anything to prohibit the court from granting such requests? Not is there authority for doing it, but is there anything that would prohibit the court?
I think the constitutional right against self-incrimination, constitutional right to privacy, against unreasonable searches and seizures. Yes, I think we're talking now about a compelled examination in which, in effect, the court is ordering a person be given access around her lawyer. I think there's a Sixth Amendment prohibition to it. I think that the short answer is that if state law doesn't provide for it, it is forbidden by about every constitutional provision I can think of.
Is there not any particular any case that is found on that?
No, and there won't be a case until a judge rules that there's such a right in the prosecution, and I don't know any judge that's ever ruled that way, so the issue never came up.
Please, Court. Estelle B. Smith, Supreme Court case, U.S. Supreme Court, that's been decided by the defense, and language there says that when a defendant asserts an insanity defense and introduces supporting psychiatric testimony, his silence may deprive the state of the only effective means it has of controverting his proof on an issue that he has interjected into the case. Accordingly, several courts of appeals have held under such circumstances that the defendant can be required to submit to a sanity examination conducted by the prosecution psychiatrist.
Well, here you got that right. I don't know about whether in that case, here there is a right to do that. Brooks is saying, there is a statutory right to have an examination. It's not for the prosecution, it's for the court.
Yes, yes.
And I haven't read that case, but in that case, was there some vehicle or was there none at all?
In that particular case, and the whole line of cases dealt with that for the most part and dealt with the issues Mr. Bruck is talking about. The majority of the time, memorandum warnings were given, and it was done in several of the cases without the defense even knowing that it was occurring. And they, of course, ruled that was improper, and that's when the Fifth Amendment came in, the Sixth Amendment came in. God, I note the Supreme Court said footnote 10, on the same theory that the Court of Appeals here carefully left open the possibility that a defendant who wishes to use psychiatric evidence in his own behalf, and on this issue in Texas as to future dangerousness, can be precluded from using it unless he is also willing to be examined by psychiatrists nominated by the state. And again, Your Honor, I think this is premature from the standpoint that we don't have the notice of insanity or guilty but mentally ill. As to that aspect of it, what I'm basically doing there is I don't want to forego my right to bring someone in at the appropriate time if need be. And that, in essence, as I said before, is what Section 3 addressed, Your Honor.
I have only stood up to make the point that Blizzard just conceded, which is we don't have an insanity defense before the court, so nothing that he cited in the court has any relevance to the issue before the Honor today. If there is such a defense, then we look at it again.
Anything further?
Honor, I would have just one final thing. Again, if I could leave the court with this one aspect. The things we talked about with Dr. Morgan, things Mr. Bruck has said, he has alluded to Susan Smith's psyche, and she's in a fragile time, and is concerned for that. And I respect his concern for that. And he's got things he can't tell us, and I understand that, and he's got a defense to run. But that's why we can have someone objective look at her and make a determination. And right now, they're basically being able to keep it to themselves and keep fighting these motions. When we get to our 10 days, they say, well, we can't decide. Arguably, they could keep on not deciding until it came up to court time. You know, I could see.
I don't think they can keep on not deciding because unless the court ran the time,
To keep extended. That's my argument, Your Honor.
and they didn't give notice, then it's not follow they can conclude from you.
Yes, sir, and I think the rule provides that. My question, and I'm sure the court is considering is,
There is a mechanism wherein the court can bring all that to a screeching halt.
yes, sir, and what I'm asking to do is the court to do that as soon as possible.
All right, well, I am going to take this under advisement. I want to study these cases. On the surface, this may be a decision that seems simplistic in nature, but it's not. It's a complex amount. Time to review the cases, statutes, make a determination. I am, until that time, I'm extending the time in which the defense has to respond to the Rule 5F request for a notice of insanity defense, but I'm not going to do that at any specific time. I'm doing this time, doing it until such time as I issue a written order concerning the matter that's been put in today. If I determine to extend it further, it will be set forth in writing at that time. This is to extend the time until such time as a written order is issued, wherein that will be firmed up and elaborated upon. If after some research the court determines further input is necessary, I will contact each side, request, obviously, my ex parte, obviously, from each side at the same time, same form of communication, such information or such further material, if any, court deems necessary and appropriate. I believe that's all for us today. I appreciate the way y'all conducted themselves during this matter, and I am aware that the exigencies of the situation, and I hope to have something in writing regarding these matters, hopefully within, we've got in Chambers Week next week, but there is a holiday in that week. There's some free commitments the court has, but hopefully within 10 days, and I'm not making that as an absolute, that's what I'm shooting for. But I don't think anyone to be knocking on my door in 10 days, won't know why I did do ourselves a trick. Like I say, I'll start here at 3, we'll start at 3. But I'll get you as efficient as possible. Anything further from the state?
Nothing from the state, Your Honor.
Anything further from the defense?
Nothing from Susan Smith.
All right, thank you. You adjourn. Yeah.